The Seminole Tribe of Florida v. Florida. This is a split 5-4 SCOTUS decision. A split decision, 1996. I'm pretty sure 1996. I may have said 99 before, but 1996 Seminole Tribe of Florida v. Florida. Split decision. It's a suit by the Seminole Indian Tribe under a law passed by Congress, the Indian Gaming Regulatory Act, to complete Florida. Let's see, to complete. So Florida, the state, to get them to engage in good faith negotiations. There's your vocabulary right there. Good faith negotiations. So the Indian Gaming Regulatory Act was to force Florida, the state of Florida, the government of the state of Florida, and the Indian Gaming Regulatory Act to engage in good faith negotiations. And who could be opposed to good faith negotiations? Well, the state of Florida. They were opposed to it, and then they're going to win the Supreme Court case 5-4 by claiming sovereign immunity. They mentioned that there's two exceptions to sovereign immunity, the Commerce Clause and the 14th Amendment. There's actually lots of exceptions to the immunity clause, lots and lots and lots of exceptions. There's the Bankruptcy Clause, the Post Office Clause, Judicial Branch Clause, the Executive Branch, Legislative Branch Clause. Then there's the Patent Clause. Specifically, there's a Patent Clause in the Constitution. So where did we get the authority? Oh, the, U.S. Constitution. You heard of it, Elena Kagan? Okay, so two exceptions to the state immunity that they admit to in the Seminole Tribe 1996 Supreme Court decision. Congress only had Section 5 of 14th Amendment as a valid source to abrogate state sovereign immunity. Section 5 of the 14th Amendment, which is, I'm not for sure. Go look it up if you want to find that out. Seminole Tribe of Florida v. Florida. They come up with a two-part test. So first, when you pass a law, Congress, you got to, ask yourself two questions. Did you specifically intend to abrogate state immunity? Did you say you had a power of commerce or the 5th section of the 14th Amendment when you passed the law? Did you actually show the pathway and where the foundation of you thinking that you have a right to this power? Did you specifically mean to abrogate the state authority, or did we already have this authority? If you meant to abrogate the state authority, then did you find a valid exercise of power in the Constitution, right? Commerce and 5th section of the 14th Amendment are already said, that's fine, you can use those things. If you're not using those two powers, then you got to find a valid, well, there's a patent, clause, right? The patent clause, and then the three branches, the judicial branch, everything I just mentioned. So the Seminole Tribe of Florida v. Florida, they just have the two-part test. So this is the important part. This is, this is sovereign immunity. And they're going to sit there and say, for sovereign immunity, for the law to be okay, and it breaks sovereign immunity, and it goes through sovereign immunity, either A, use the Commerce Clause or Section 5 of the 14th Amendment, or B, you said, we're going to abrogate the state immunity, the power of, sovereign immunity of the states, and we're going to find a valid exercise of power from the Constitution. That's not Commerce and 14th Amendment. So you got Bankruptcy Clause, you got the Post Office Clause, you got the Army Clause, you got a lot of clauses. The federal government, necessary and proper supremacy, they always bring those two out. Authoritarians always bring those two out. So that's always there for, ever and ever. Necessary and proper supremacy clause. So yeah, there's a two-part question, a two-part test, two-pronged test to test a law by Congress to see if it actually, measures up with their fucking sovereign immunity legal fiction. Did Congress specifically mean to abrogate state immunity? And did they find a valid exercise of power in the Constitution? Rehnquist, he's going to write the opinion of the court, 5-4 split decision. Stevens and Souter wrote dissents. And SCOTUS says Article 1 of the U.S. Constitution doesn't give Congress the right to abrogate the sovereign immunity of the state protected by the 11th Amendment. SCOTUS, 11th Amendment, there's no sovereign immunity in Constitution. SCOTUS said inexplicably that Ex parte Young did not apply because any remedy was limited to the one that Congress had provided. So yeah, Ex parte Young, that's Supreme Court decision, it's important, major, blah, blah, blah. But, Congress has to make sure they abide by our legal fictions, and then they also have to make sure they list all the remedies of the, supposed crime, right? So Seminole Tribe and Florida government supposed to get together, good faith. They didn't want to do that, spend millions of dollars. Florida government said, fuck that. We're not going to get in no good faith to fucking go negotiations. Good faith negotiations. Government of Florida said, fuck good faith negotiations. We're not going to do no good faith negotiations with the goddamn Seminole Tribe, Florida. That's what the government of Florida said in 1996, and the Supreme Court upheld it. So, 11th Amendment, they created a legal fiction. They did that shit. Ex parte Young doesn't, Ex parte Young is on my side. It's on my side, so you can't just fucking throw Ex parte Young out. So, yeah, that's the Seminole Tribe of Florida v. Florida. I ended off with a quote of Abraham Lincoln during the Dred Scott decision, or the worst fucking decision in American history. Abraham Lincoln said this on the Dred Scott decision, I think during the Lincoln-Douglas debates. At the same time, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. That eminent tribunal, that's beautiful, right? It makes it sound like Supreme Court's eminent. It's eminency, it's sacred, it's majestic. But he's shitting all over it, and he's saying we're going to be slaves. If we allow the Dred Scott decision to go ahead and govern all of our thoughts, then we have just become slaves to the Supreme Court. So the Dred Scott decision, Plessy versus Ferguson, Supreme Court's, fucked up over and over again. And fucked up with the Seminole Tribe. They fucked up with the Allen v. Cooper decision. They fucked up Plessy, Chaplinsky, the Hans decision. They fucked up a lot of times. Over and over again, the Supreme Court fucked up. So I feel like them leaning on stare decisis and precedent. Well, precedent. You can't think for yourself. Precedent. Oh, the previous judge said this, so we're just going to go along with it. The Supreme Court is not infallible because they can do no wrong. It's because they make a decision when nobody else wants to make a decision, and it's the right decision. So Roe v. Wade, Obergefell v. Hodges, the abortion case and the gay rights case, these and even the individual right ownership of guns. The Second Amendment protects not if you're a part of a militia, but if you individually own, you have an individual right to self-defense. And so, therefore, it means that the person, the individual themselves, have the right to own a gun. So all these, they're the right decision. They're the right decision in terms of, morality. Now, that's, to be thrown up in the air, but they're the right decision also in American jurisprudence. So we looked at the laws of the land, and if you get married in Maryland and you move to Ohio and your spouse dies, you're allowed to put your name on the death certificate, even in the state of Ohio, because Maryland had recognized the marriage. So even though Ohio wants to discriminate, the 14th Amendment says we have equal protection and due process. You can't take away people's rights without the due process of law. So you're going to have to take, that Obergefell to court. All he wants to do is put his name on a death certificate of the person that he spent his life with, that he loved and loved him back. His special one and only. He just wanted his name on, and then, they would want his name on the thing, on the death certificate too. So that's the right decision. They used American law, forwarded a logical progression of the law in order to protect more people and to be more equitable and to allow justice to reign free. So the Supreme Court could fuck it up. The Supreme Court fucks up a lot. The Schenck decision, they fucked over this guy that just said, fuck the draft. Nay, that draft? Nah, fuck it. Okay, you go to jail. They threw a lot of people in jail back in the Schenck era, a lot of fucking people. Eugene Debs and Abrams, just for throwing a pamphlet out the window. They threw a flyer out the window, and then they went to jail for it. At least that's, what I read. So, yeah, that's the Seminole Tribe v. Florida v. Florida. I don't know, there's a bunch of fucking, just read it yourself, Stevens and Souter, they wrote Dissents, And, you know, Seminole Tribe got fucked in it, so sovereign immunity, this is just a case that they pull up for sovereign immunity. A bullshit legal fiction. And you know, peace.